Erick Mukoya is my name. I work for Legal Resources Foundation. Legal Resources Foundation is an organization working in the criminal justice system in Kenya for the past 27 years. And their work is to ease access to justice for the poor, marginalized, and the indigent. By training, I am a lawyer, but not an advocate of the High Court, so I don't practice. Nonetheless, I empower communities to understand the import of law in their day-to-day activities, and therefore increase the effectiveness of law if it is well applied and is interpreted in the manner in which it was purposed for. For you to respond to a question of COVID-19 and the rule of law, you must invite a number of issues that then converge to arrive at a verdict, whether it is rule of law or misapplication of law. Number one is to ask yourself, in what context has COVID-19 manifested in Kenya? Number two is to ask, what are the issues that arise when you put measures in place? So that means we start looking at the Constitution, but basing our argument on the Bill of Rights. And we are looking at two things here. One is the desire of the country to ensure that infectious diseases do not spread. Considering that it's a pandemic and considering that there is no vaccine, it means the best you can do is preventive measures. In that context, therefore, you need to apply the Public Health Act. Public Health Act provides directions on what the government, through a cabinet secretary, is supposed to do to ensure that infectious diseases do not spread. Nonetheless, why do you bring in the question of the rule of law? It is to ask whether isolation centers, is to ask whether emergency rules where people have to keep time, where people have to avoid certain gatherings, is it within law? If you follow the Public Health Act, it is. But that does not mean that it does not conflict with the Constitution when you are looking at freedom of association, when you are looking at freedom of movement, and you are looking at freedom of expression. Does it remain suspended? No. Does it provide an angle at which you can circumvent the Constitution? Yes. In what context? That human dignity, which is Article 28 of the Constitution, is non-negotiable. And if it takes an institution, it takes a cabinet secretary or a president to provide directions on how that dignity can be sustained, meaning that people are ready to negotiate on the social contract they have with the government and say, yes, it is right that for our health, we require to follow some of the emergency rules. So in that context, it is within law. At the point at which it goes outside the law is when law enforcers then go overboard without understanding the dynamics in which some of those rules have been put. That question then now speaks to what are some of the measures that the government has taken to contain COVID-19. So number one is that the government has insisted there must be social distance, which is a public health practice guide, that for us to associate, for us to speak to each other, we must keep social distance of 1.5 meters. Number two, they have said no gatherings. The traditional court system in this country is about gathering. Any litigation matter has parties. Often we have an opposing party and we have the alleging party. And you would guess that these people require to listen to what the judges say, to what the prosecution says. And in that context, therefore, COVID-19 has stopped the traditional way of litigation. If people have to meet in a court of law, if people have to make submissions in a court of law, it will only be possible if crowds are avoided, which is a culture that we must begin embracing. That is one. Two, if you look at how correctional facilities in this country, and I would like to talk about pretrial detention. Pretrial detention is where people have been arrested, and for one reason or the other, they find themselves in remand homes. The remand homes in this context, because Kenya doesn't have separate remand houses, it means prison facilities act as remand homes. And if you go to the records, we have many remandees in this country than convicts. Out of 54,000 people in prison, half are remandees, meaning there are people whose matters are still in court. They have not been decided yet. What does that mean? It also means that the capacity of correctional facilities is inadequate to have 22,000 more people while it's supposed to hold on 7,000 people. What does that mean? It means that COVID-19 in that context may not be contained, not unless we find mechanisms and measures to reduce the number of remandees who are lying in prisons which act as remand homes. What that therefore means is, can an advocate, even without having a poor client, can they access prison facilities? They cannot. There's a ban by the government that no visitors will be allowed into prison facilities. And in that context, COVID-19 then harmonizes both poor and rich in the context of accessing justice, that it remains a threat to how justice must be dispensed. Nonetheless, if justice actors think outside the box, it is an opportunity for them to integrate IT into how they run litigation matters in this country. The court system in this country, under the judiciary, is independent. So it has a budget, and therefore it can invest in IT, it can invest in infrastructure, can invest in personnel. Similarly to the Office of the Director of Public Prosecutions, which even enjoys funding from the European Union. What about Kenya Prison Services? It is a government department, meaning that its budget has to go through a ministry. Do they have the facilities? They don't. They have been relying on government organizations to give them even bundles to hold court sessions online. What does that mean? It means in the absence of partners, the court will do nothing because the people who are supposed to be tried are in remand, meaning they're in prison. So when you look at that, then you start seeing the ineffectiveness of whatever approach that has been taken. Number two, our interaction with justice sector actors, specifically state, indicates that they don't know how to use IT effectively. And therefore, you are importing a technology that you have not trained people about. What does that mean? It means there'll be a lot of idle time, there'll be a lot of loss in the time spent for people to understand a system. That is something they need to address. Number three of that is to ask yourself, is it necessary that all matters must go to court? We come from a very litigious community, and there is need that context of dispute handling is handled differently. Why? We have alternative justice systems, we have traditional methods of dealing with disputes. We need to revive that. Article 159(1)(c) of the Constitution is very clear. You can do mediation, you can do arbitration. Not all matters must go to court. And COVID-19 is that opportunity to move or to make that shift. I'll respond to that question by bringing in one thing that most of us ignore, which I call the culture around law. And I want to give you an example, a simple example that will demonstrate what I want to say. If you are driving on Kenyan roads and there's traffic, you get angry when someone gets off the road, drives on the pavement, and finds you rightly in your lane, and kind of demands that you must give them way. I mean, the law is clear that you need to follow the queue. Everyone is following the queue. What gives you the audacity to get off the road and still gives you the audacity of requesting that you must be brought back to the road? for somebody who's following the law. So there's impunity around law. And that needs to be contextualized as we talk about this. There are a number of rights that are threatened by COVID-19. One, you have health rights. Health rights in the context that because of the fear and stigma and wrong messaging that the state engaged, many people stopped going to hospital. And therefore, their health rights were threatened. For the fear of getting COVID-19, for the fear that these other diseases are now not important because COVID-19 is important, it discourages people from going to hospital. Already that's a problem. Problem number two on that very, very point is that even as government began dealing with COVID-19, they actually told us we are going to pay for our bills. Nobody wishes to collect a disease. It is the role of the government to ensure that whenever there's a pandemic, it is their duty to ensure that people are treated. Yes, there's a section of law in public health that says if you treat someone and in your estimation they look like they can afford, then you treat them first, release them, and follow them up to pay part of that medical bill. That affected many people. Even people who had COVID-19, you've seen some people disappear. Why? Because they don't want to pay bills. They don't want to pay quarantine bills. Because in the first place, they did not ask to be quarantined. Number three of the same point is, who gives government the right to quarantine anyone? The Public Health Act is very clear that before you quarantine someone, there must be a medical report. So you get a medical report. After getting a medical report, you take that person to quarantine because then you're telling them you are a threat to the others. And just because Bill of Rights says that your right is not absolute, it's at some point it stops the moment it starts offending another person. And therefore, your right to remain with freedom is limited to that extent. Having said that, I would like us to look at the right of livelihood. People need employment. We have put curfew. Is it in bad faith? No. Why does it turn to be bad? Because the government did not plan. COVID-19 did not begin yesterday. It wasn't a surprise. Go back to December 2019. The government through the ministry required to have begun preparing and looking at the possibilities of saving people from the difficulty of losing their jobs, from the difficulty of losing their livelihood. And therefore that means that when you hear of stimulus packages, that hotels or the private sector has been given 3 billion or 5 billion to set up and restructure so that they survive within the pandemic, it means the government has looked at the losses that are likely. And those losses include people's jobs, and decided to save such sectors from imminent collapse. Nonetheless, does it justify why people must be removed from their houses? It doesn't. It speaks to the plan I'm talking about. And I'd like to take you back to the governor of New York. What Cuomo did was to pass a law that said, for as long as you're affected by the pandemic, you'll not pay rent. And that was passed at the level of the state. What did this government do? Did not do anything. Political rhetoric does not amount to law, does not amount to regulation, does not amount to a guideline. So that is one problem. But problem number two, even where the law says that you require to stay in a house 3 months, there are procedures. You just don't wake up one morning and decide that 3 months will elapse and I have to stay in here. You must seek the audience of the rent tribunal and explain yourself. In context like COVID-19, we'd have expected the tribunal to be proactive and therefore reached out to people who have problems, particularly people living in the slums, and tried to find ways in which they could be helped. So the law is there, but the implementation of that law depends with what culture have we generated around law. For example, why would the government evict people during COVID-19? Because there's a culture around law that government knows. The courts are not sitting. So if they evicted you, they will fence off. By the time the court is sitting, they're already occupying the land. And government is government. It's difficult to move government from a space of land than it is easy to move a human being. So therefore, the culture around law, that the government times when the courts are in a lull, they'll ensure that you have no space to go and make a petition. And that's the time they evict you. On humanitarian grounds, it's very wrong. In law, it's more crude. Why? Because the government is the custodian of people's rights, and therefore the law, they should not be the first ones to break it. So we may not have mitigation as to why that happened, but the baseline is it was done outside the rule of law. That's a relative question and political in nature. But before I respond to you how far, it's good to contextualize to understand that Article 34 and Article 35 of the Constitution are very clear about freedom to access information. It's also clear about what media houses are supposed to do at Article 34. So looking at those two and inviting the concept of national security, which is always what the government invites whenever they are put to task as to why they are clamping down on other people. There is no merit in spreading misinformation. There's no merit. And my thinking is, if anyone is found to be deliberately spreading misinformation, then appropriate action needs to be taken, because most of our decisions are made based on information. Nonetheless, that does not mean that the government stops people because they are not so sure who they are to spread the right information. So it's a delicate balance. Delicate balance in the context that we want information, but the question you're asking, how reliable are the sources we have for information? How many times has the government spoken the truth? So if the government is not believable, it opens us up to believe other sources. So the first thing the government needs to do is to put its own house in order. So if the government is transparent and they're accountable, for example, at some point we were told that they spent 4 million to take a cup of tea. How many Kenyans spend 5,000 to take a cup of tea? So we quickly start thinking the government is covering its own corruption. And therefore, till the government establishes mechanisms and means for us to believe it, that they legitimize the information they give us, you'd be sure we'll rely on the other sources. Whether we are being misinformed or disinformed, we'll care less till we get the truth. So therefore, the government has no moral right. It could have legal right, but they have the moral authority to clamp down on anyone because they have never told us the truth of the many things that Kenyans will have loved to know. And that speaks COVID-19. You will hear people say this is a scam. You will hear people say the government wants money from World Bank. Why? Because people don't just believe their government. And it should be the most reliable source of information. So the extent to which they need to go will only be described if they are ready to be as transparent and to be as accountable to the people with whom they have a social contract. Even if they have to question, they need to be quite objective with why they do that. The subjectivity by which they handle the matter is what creates more problems. Because if you take me to court because I have a blog and the blog has said something you don't like, I mean, you have other mechanisms of dealing with me. I mean, you can sit down and talk to me and say, these are the facts. This is not factual. And make me correct what I have written on the blog. Make me make an apology. I mean, media houses do that. They use your wrong picture or they use someone else's picture on your name. The next day, they make a small apology. Well, I don't really like the small apology because they put it somewhere where nobody will. But it should be the same approach that when we make mistakes, we come out and we apologize, say we've made mistakes. You remember the case of, which wasn't in right though, the case of Magufuli and Citizen? Do you remember?
Yes.
And they made Citizen apologize for a week?
Yes.
All the time?
Yeah.
Why didn't Magufuli take Citizen to court?